law matters. Of course it does. Welcome once again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and some practical assistance to help you with the law matters, because the law matters. A better understanding of the law puts you in a better position to decide how to help yourself, your family, and at times your business. As we present various topics, you may in fact decide that you want to handle some issues yourself. We try to help prepare you for those times. If you do decide to seek outside professional counsel, our goal, of course, is to help you achieve the best possible results, prepare you, and help you save time and money. As always, we want to welcome and thank once again our attorney, David Bizarre, from the Bizarre & Associates law firm in East Providence, who continues to help provide legal information and sometimes some very interesting anecdotes on the topics that we will discuss. So today, wills versus estate plans, the similarities, the differences. Inflation, as we speak of this today, can have some significant impact on someone's ability to save for the future. Right now, some people are calling what we have as a bit of a crisis. Some are freezing their decisions to make purchases. Some are not. In either case, those are short-term thoughts. However, that doesn't mean it's wise to postpone planning for the future, a longer-term prospect. Estate planning isn't just for those who are very wealthy, and it's certainly about far more than the value of your assets on any given day, and David's going to be discussing these things. Even if you don't have a very expensive home or a very large IRA, there are some things that you might want to take care of, and so you can benefit from creating one of these instruments. We're going to discuss which one, why, and what the differences are. So before we begin and ask David some of the specific questions, there are some interesting factoids as of 2022 that we'd like to share with you. So for example, Caring.com did a wills survey and finds that 1 out of 3 Americans without estate plans think they have too few assets to leave behind. Another interesting issue, since the beginning of the pandemic, the number of 18 to 34-year-olds with estate planning documents has increased by 50%, an interesting trend. And according to a New York Times survey, nearly 9 out of 10 adults were concerned about inflation, and this fear of inflation was what played a critical role in how people perceive their finances, and it often led to postponing they're making these decisions. So let's start with, some people think that wills and estates are the same thing. They're not. What are they? What are some of the differences, David?
Generally speaking, an estate plan is more than a will, and it's more than a trust. It's a bunch of different things, documents sometimes, but the way I approach it is someone comes in to see me, and they have certain concerns or goals that they want to accomplish. So I like to start with that. What are your goals and what are your concerns? And then build around those concerns or goals the kind of plan that they need. So an estate plan can be a will-centered plan or a trust-centered plan. And it depends, again, on what it is you want to accomplish. And it's more than, the trust is a living trust, a revocable living trust, because you create it while you're alive, generally speaking, and it can change and it can be shaped to what you want to accomplish. A will doesn't come into play until you die, and so there are other documents that you need in place while you're alive.
And some people might use and think about both, but really not know the differences. So when you ask, what are your plans, I would imagine most people think, what am I going to do with this when I die? How do you bridge or broach the subject to say, well, we can handle those things about when you did, but what about what's going on now? How do you play that out?
We like to talk through the dynamics of what brought you in, what your concerns were, what it is that you want to accomplish. And so in doing that, there are 2 different types of things that go into a plan. The 2 real most important things, though, are the people and the property. So the people is where I'd like to start because I find it more interesting. And who are the people that are involved in your life? Who are the people you're concerned about? Who are the people you want to care for? And who are the people you want to care for you? So we'd like to talk about the family and the family dynamics first.
I guess, as we usually say, we want to help people even if they don't choose to use a lawyer. So my initial reaction is, of course, someone's likely to go online and look at wills.com or whatever that might be to see what they could do online without using a lawyer. Just in this past minute and a half or two when you've spoken about it, I'm not sure that any instrument that is available online is anything more than maybe a mere introduction, because I can't see how a will could possibly ask about those interrelationships that you're describing.
Right. The documents you can get online are just that. They're documents. What you're going to get from an attorney who practices in estate planning is advice. And you're not going to get that advice from filling out a will, which you may or may not fill out correctly online and may not have it executed correctly so that it is a legal document that can be used if you die. I've had those cases where people come in and say, well, here's my dad's will. He did it online. Yeah, but he didn't have anyone witness it or sign it correctly, so the judge is not going to accept that into probate. It's the advice, though, that I really think is the most valuable commodity that an attorney can lend in this planning process. And it's, you tell me about you and teach me about your family and your situation, and then I'll teach you about the different types of things that you can do to accomplish your goals.
Having been through it, I always found interesting the questions that are asked. So before you're giving advice, obviously you're asking plenty of questions, and it was invaluable to have someone probe a little further and ask a little more about things that I couldn't have possibly anticipated. And that's right. Pretty far down the road. But initially, someone is likely to say, David, make this simple on me, will you? And that just means, here's my collection of things, and that's that. And you're already saying, not necessarily.
Well, the plan itself can be simple and
yes.
straightforward, and that, but to get to that, let's make sure we didn't miss anything. So, for example, you were talking about some of the questions and the probing and so forth, and a lot of times someone will come in and they'll say, well, I really want my sister to be the executor of my will or my power of attorney, but I'm concerned because she's older than I am. And I like to say, well, that's who you want today. Maybe not in 5 years from now, but look at this in 5-year increments. And let's say if the person you want is the perfect person today, then pick that person today. In 5 years, if that changes or if something happens in between, we can always change it.
It makes sense. So with a will, and you approach that first, if that's one of the things that someone needs to take care of initially, what are the kinds of things that will be included in a will?
Well, someone comes in and they say, here are my concerns. I want to make sure whatever I have gets to my 3 children. And so, well, that's fine. Let's talk about who your 3 children are. Do your children have children? Are they married? What's your relationship with your children, with your son or daughter-in-law, for example? How old are your grandchildren? So why do we ask those questions? Well, we know it's simple enough to say, as of today, I've got 3 children, they're all fine, and they're going to get my things. But what happens if something happens to one of those children? And do they have children, and do you want it to end up with your grandchildren? Do you want it to go to your son-in-law or your daughter-in-law? Where do you want your things to go if something happens that you're not really thinking about or anticipating right now? So that's why we need to develop the whole story about what it is that you want and who are the people that you want to share in it.
So when someone comes in to you to discuss this, at what point do you decide or determine that they need to also pull in another person, such as a financial planner? Let's not even talk about a tax advisor in case everyone's concerned, but people are concerned about that as well. So how do you know when someone else should be part of this process?
Well, first we need to determine what the process is going to be, because you talked about a will. So when someone comes in, what are generally the concerns or goals? One of them is usually making sure my assets get to the next generation. Sometimes people come in and they're concerned about, well, what if something happens to me while I'm alive? Who's going to take care of me? So that we call disability planning or incapacity planning. Some people come in and they're worried about, if I become a vegetable and I'm going to be hooked up to a machine for the rest of my life, how do I avoid that? So we like to find out what the goals are. Sometimes people are worried about, they call it nursing homes taking their assets or my house. So Medicaid planning or Medicaid protection of assets. And sometimes people come in who are very wealthy and want to make sure that whatever goes to their children is protected for them for the next generation or the generation beyond that. So that's usually a trust-centered plan. So the first thing we have to decide is it going to be a will-centered plan where the will takes care of what happens if you die, or a trust-centered plan where the trust takes care of that? There's a little misconception that there's no will in a trust plan. There is a will in a trust plan, but it's a pour-over will, which means whatever assets hadn't already been put into the trust are poured over into the trust if you die and they have to go through probate.
That spillover or pour-over, that can change, is that the easiest document that can be changed among the rest of the documents that are there?
All of them can be changed at any time. So for the person who's using incapacity as their biggest concern, part of the documents that we would use would be a power of attorney for finances and a healthcare power of attorney for medical decisions. And oftentimes what changes in that is, who do you want to be the person who's going to carry out your wishes and to take care of you if you can't do that, and make sure that your medical decisions are made in accordance with the way you want to make them. So to that end, in our living will or healthcare power of attorney or Massachusetts healthcare proxy, we try to spell out all the different things that might come up so that they know what your wishes are.
And how do you get to someone in the family would be very good at taking care of my financial issues, but it should be somebody else who really understands more about what my medical choices and decisions might be when that time comes? How do you broach that? Many people say that they don't want to get involved in any of these discussions because it's very uncomfortable. Uncomfortable, A, because they might have to talk to their spouse or someone else, and it's uncomfortable because no one wants to face the fact that they, like, what's the two truths? Taxes and death, that they are going to die. Not comfortable. How do you deal with those things?
Well, first of all, we talk about estate planning as a gift to your children or your spouse, because what you're doing is you're making sure everything's in order, sort of like a rehearsal by putting you through the questions that we have to put you through. And so we're thinking about it not in terms of, oh my gosh, I'm going to die, because yeah, you are, but more in terms of, I want to make sure when I do die, or if I become incapacitated, that I have everything in place and plan so that it's easy for my spouse or my children.
We didn't touch upon this, but some people have businesses too. Does that mean that they absolutely have to have an estate plan?
Everyone should have an estate plan, whether you have a lot of assets in businesses and business succession issues and that type of thing, or you have a house and you're just worried about protecting your house, or if you have just other assets that you live on and need day to day, and you're not worried about passing those assets to the next generation, but if there are any left, you want to make sure it goes to where you want it to go, and also making sure that there's a plan in place to take care of you if you became incapacitated. Everybody should have an estate plan.
And while we're talking about that, let's address well, I might not have much in assets. However, what I have, I don't want anyone else to know about. So discuss the privacy issue.
So when you do a plan, nobody has to know what you have. You know what you have. Your lawyer should know what you have so that you can be given the correct advice. But what people would need to know is, if you have someone appointed as a power of attorney, for example, they need to know what bank you have so that when it's time comes that they need to do that for you, they know where to go. So when we do a plan, we put together a binder with all of the documents, and in that binder is some of the other information that people might need to know if they're coming either after you pass or after you become incapacitated, so that they have an idea of where they need to start to look and to do things for you.
So for those clients that you may have right now who have estates and the pour-over will, people are talking now about inflation and about their stock portfolios that have changed. What do you say in general? Obviously, every circumstance is different, but do you have any general thoughts about whether or not someone needs to review what's in each of those documents because of the changes in the economy right now, versus how I want to treat somebody is different.
Well, it depends on how you had your documents written in the first place. Sometimes when you're going to give a specific amount of money to someone, a specific bequest it might be called, whether through a trust or a will plan, you just say, this is the amount of money that I want them to get. What we do sometimes when there's a concern about how much assets they're going to be and what you really want them to get, we might put in something along the lines of this specific amount of money or this percentage of my gross estate for federal tax purposes. So we have a way of defining what the gross estate is and having that percentage as the floor. So either the lesser of this amount or that percentage, so that if your assets do fluctuate quite a bit, you're not going to give somebody a specific amount of money that's more than you really anticipated based on what you have.
Clearly, I'm sure that's something people don't necessarily think about, but that's a very good point and a very interesting way that you can make sure that someone has their true wishes covered once you
and the
explore
plan's
that.
in place so you don't have to go back every time the stock market goes up or down.
Have there been recent changes in state laws, whether because of the economy or probably more importantly, that changed in view of the pandemic when people were concerned about their finances? So have laws in each of the respective states or at the federal level changed drastically in the past year?
Not in terms of estate planning where there, for example, there was a time when we were in the midst of the pandemic and you couldn't really see people in person easily. And so we did want to try to change how wills could be executed, and maybe witnesses could do it remotely or that type of thing. We were able to put in place, in Rhode Island at least, the ability to notarize documents remotely, but not wills that had to still be executed in person. So that never changed. And there's always changes, but generally speaking, it's on tax law and estate taxes, and that's what you see, or the Secure Act in 2019, where the changes were made to how you could inherit retirement plans and what you could do with retirement plans, that type of thing.
So I know at the top of the segment we were saying this isn't just for the incredibly wealthy, but for those who are in that category, that gift tax, the estate tax, there are several zeros involved, that those who have that kind of income or that kind of asset or wealth, they are going to be careful about what they're doing and might trigger a need to see their tax accountant as well as their lawyer when this is going on.
So I didn't ignore your question, I just never got to the answer about when you would have a financial person involved. Oftentimes when we're doing a trust plan, in order for a trust plan to work, you have to make sure the assets are titled correctly. So if you have an investment plan with a broker, we'll make sure we're in touch with the broker so we can give them the information to title your investments in the name of the trust. If it's a non-retirement type of asset, if it's a retirement asset, we want to make sure the beneficiaries are named correctly. So when we do a trust plan, one of the things we do that a lot of lawyers actually don't do is not just do the document and say, here's your trust, but we help fund the trust with your money so that all of the assets that belong in the trust are put in the trust at the time you create the trust.
When we talk about reasons that people avoid this, if they've heard anything about estate planning, I've heard so many, not just waffle, but clearly say they don't want to be involved with because getting those titles, getting them renamed, getting them to you or to a lawyer who then puts them in the trust, that's a piece of work that often people don't want to get involved in. So even if you went through the process or the exercise of preparing the estate, it isn't done until those deeds are actually renamed and placed in it, correct?
And that's part of the process that we do. So we try to take some of the weight off your shoulders by making that part of our process. And again, remember, if you die, someone's going to have to figure all that out. So it's that gift to the family by doing it in advance and having it done correctly. And that's part of the reason we insist on that second piece of making sure it's funded correctly, and that we do that so that when we give you the final product, it's done. And of course, it'll change over time. So we will meet periodically to make sure that if there are new assets, they get funded in and that type of thing. But to do it correctly, we do have to deal with your broker, certainly sometimes your accountant and whoever else. Banks don't want to talk to lawyers, so we'll give you the correct documentation to take to your bank so that that can get funded in. But for the most part, we will walk you through the process to make sure that when your trust is completed, it's funded.
Good to know. Let's talk about beneficiaries. People often have insurance policies that name beneficiaries. And the comment that I read is that many who have said that that tells them that they don't need a will because the beneficiary is clearly listed there. Or they have a joint bank account with their spouse. No need to have a will, that's where it's going. What do you say to that? Obviously there's more to it, so.
Well, yeah, there's, that is an excellent way to pass assets and avoid probate, which a will would be required to use to pass assets that are in your name alone. But you should have a will, if for nothing else, if you were killed in an auto accident and someone needs to pursue a claim on your behalf, that it's the claim of the estate, for example, that may want to bring that. And so who do you want bringing the case for you, and where do you want the assets to go if they're recovered on behalf of the estate? So even if you think you've covered beneficiary designations and joint accounts and everything 100%, you can't cover assets that you don't know you may have at the time of your death because of a wrongful death or a medical malpractice or whatever else it might be.
So let's talk about for a moment, what happens if someone doesn't have a will? You said it triggers probate, and I do want to explore that, but also, do the insurance companies have to read the obits every day to find out who died so that they can contact a beneficiary?
Yeah, they don't really do that.
They don't,
Yeah.
of course not. So
Right.
Explore that.
Yeah, there are some people who do that, but those are creditors looking to make sure they get paid.
Exactly.
So if you don't have a will, then the law of the state in which you lived will cover where your assets go. It's called intestacy law. And if you die intestate without a will, every state's different. There's nuances, and there's no control by you anymore because you're gone as to where your assets are going to go. And really even who is going to be the person, the administrator or administratrix, to carry out the function of gathering your assets and distributing them.
So at the top of the segment, we said we like to save you time and money. I don't think people consider how much more costly it could be to not have a will, because at the moment there's probate and someone decides to challenge it, I can't imagine how much time and money, enlisting more lawyers to battle that out. Care to address that?
Yeah, if you want to save time and money, if you die, see a lawyer before you die and create an estate plan that covers exactly what you want to do. Here's, you asked about some of the questions we asked. Well, we know what you want to happen with your assets if your children are here or your grandchildren are here or your siblings are here. But what happens if nobody's here that you anticipated leaving money to? We call that the remote contingent beneficiary. It's not very likely to have. It's the hardest thing to think about. But as lawyers, we think about everything. Some lawyers call it the nuclear war provision or the family vacation provision where everyone's on a plane together and it goes down. Where are your assets going to go? So that's something that you need to think about. It could be other family members that are more remote, or it could be charities. But again, something that we cover. And to have a complete plan and make sure it's done the correct way, and you want to save time and money, see a lawyer who does estate planning.
And how about when you want to disinherit someone? If maybe you don't care about privacy if you decided to disinherit your spouse or your third child or whatever, but it seems like that's something that would certainly need some careful documentation.
Sure.
Address
You definitely, and you can do, whether you do it through a will or a trust, there's definitely language that needs to be put in. It has to be intentional and not the result of mistake or oversight. We often like to put in language as to why we're doing that. You know, no longer a source of joy to me, or hasn't been a source of joy to me for many years. Or I provided for this particular person during my lifetime. So whatever the reason is, and again, you don't have to be too specific, but certainly you have to be specific enough that the person who you are leaving out is being left out and that it's intentional and not a mistake or oversight.
And for as thorough as you are, and as many times as we've had any of these discussions, you've always said it's all about documentation, documentation. I understand that many people these days often want to have a video made. Is that something that you are either recommending or that you are part of so that people can, if they so choose, never mind, want to talk about their entire life, but also some of those choices that they made and why they made them?
For the most part, we don't do that. And the reason we don't do that is because we don't do it for the most part. So I always felt that if someone wanted to do that in a particular case because they're leaving someone out or there's a question about their capacity and all of that, well, is it a reason to challenge the capacity because we did do the video and we don't do it for anyone else? We like to use documentations. The documents speak for themselves, but there may be, and certainly into the future, more of that where someone wants to actually speak to people and why they're doing things. And if they want to do that, that's fine, but the documents still have to speak for themselves.
Good point. And one other question relative to probate. Probate means that it's put in the newspapers or it becomes a public document. If there isn't someone who is likely to have been named an executor, can someone step in and say, it should have been me, I want to be? Can you, the state, the city, the town, a judge, appoint that person? And how does that process take place?
So if I'm following what you're saying, if you don't have a will that names an executor, so you don't have a will.
Yes.
So we're dealing with an intestate situation.
Yes.
Then it's an administration, and whoever wants to petition to be the administrator can. If other people think they would be more suited to it, then we can have a battle in probate court and let the judge pick who's going to be the person, or make two people do that.
And does that happen actually?
It does.
And does that both prolong the time and the expense, as I would imagine that it does?
It does, because certainly just to get the estate in place may be delayed because there's a fight as to who's going to be the person to do it. And the person who's doing it now has to report back to the judge and get permission to make distributions and do all the things that they need to be done as it goes along. So it makes it more difficult, and it can be more costly. Because in a will, generally speaking, the judge is going to require the executor to put a bond up, but usually it says without surety, meaning you don't have to go to an insurance company and have your bond insured, which costs money. If there's an administration and people are fighting, a judge may require that you incur more expense by getting a surety bond.
Good information. We hope that this has been helpful to you in your short-term and long-term planning, and we hope you will continue to stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.